Can you still hear me, Professor Brockle?
Yes, you sound great.
Okay, perfect. I can't see because I'm sharing my screen. So thank you everyone for being here. We're excited about this event today. This event is sponsored by both the Litigation Center and Society of Litigators. So we want to thank everybody who went into planning this event and putting it together, doing outreach for us. Just wanted to thank everyone. Before we get started, I just wanted to give you guys a few notes about the presentation today. You can ask, so throughout the event, if you have a question, go ahead and write it in the chat. And then towards the end of the event, there will be an audience Q&A session. And I will read those questions aloud that you've popped in the chat throughout. And then Professor Castoria will have an opportunity to answer them. There will also be a raffle at the end of the event, so don't run out too quickly. And then Professor Brockle can speak more about the raffle.
Yes, so the two raffle items will be a book on the history of the Supreme Court of the United States. And then also Professor Castoria has generously offered to sign a copy of Thomas More's merits brief to the Supreme Court of the United States. So that'll be pretty cool to be able to see the actual document that was utilized during this process. So thank you, Professor Castoria, for offering that up as a raffle prize. So stay tuned at the end, and we'll be giving those away to 2 lucky individuals.
Thank you.
Thanks, Professor Brockle. So we're going to get into the event now, and we're grateful to have our very own GGU professor here, Professor Louie Castoria. For those of you who don't know Louie, I'm going to read a bio before we start the event, and then we'll get started. So Louie Castoria is a partner at Kaufman, Dolowitz & Volek LLP, a national firm, where he has co-chaired 2 practice groups and founded the Appellate team. He is an adjunct professor of law at Golden Gate University who won his first U.S. Supreme Court case on July 1st, 2021. He is a mediator and mandatory settlement officer with the San Francisco Superior Court and founder of a nonprofit charity, the Coastal Literary Arts Movement. In his spare time, he writes a weekly humor column for the Half Moon Bay Review. Professor Castoria teaches 2 classes at GGU Law. In the spring semester, he teaches civil litigation pretrial, and his current class in the fall is overcoming civil litigation obstacles. He's a graduate of Berkeley Law and the University of San Francisco, where he was valedictorian. So thank you for being here, Professor Castoria, and go ahead and take it away.
My pleasure. Thank you. If I don't have volume enough, let me know. Everybody raise your hand or shoot me an email or something. I really appreciate the chance to do this. I want to say to all the people who are still students who are here with us, I really admire what you're doing right now, going to law school and facing all the obstacles that entails, and at the same time dealing with a pandemic and not knowing where you are, come back to college or not. It's certainly a bunch of obstacles I never had to face when I was in law school, and I appreciate the sacrifices you are making to complete your education. So when this came up, after July 1st, I notified GGU that we'd won the case. And they said, well, we could get some information out of this educational content. And the way people learn the most is from other people's mistakes. So would you mind just doing a presentation about the mistakes you made? And I said, well, if I had a 3-unit full semester course, I could do that. I said, well, how about the things you did right? And I said, I can do that in 30 minutes. So that's why we're doing this way. You may wonder why the case is important. Of course, it's very important to me. It's my first Supreme Court case, but it's important for society because we got a facial unconstitutionality ruling from the Supreme Court for California's Attorney General's demand that 501c3 nonprofits divulge their donors to the Attorney General's office. And that had never come up before this case. So when we challenged it, we did it on behalf of Thomas More Law Center, which is a nonprofit public interest advocacy group, advocates in court peaceably. And we also asked for a finding that it was facially unconstitutional. That had been foreclosed by an earlier case. In our case, at the end of the story, Chief Justice Roberts and the others in the majority said this is facially unconstitutional, which means no nonprofit operating in California has to turn over their donor list to anyone. And it may have the broader impact that in other states, if attorneys general make the same sort of demand, the same should be the ruling. So it is nice to have something go big. How did a case like this come to a guy who for 42 years now has been an insurance defense lawyer? Good question. It came in through an insurance company. Thomas More Law Center has professional liability insurance since they do legal work. And they turned over the written demand from the Attorney General to their broker, who said, well, this is not a claim, but I'll pass it on to the carrier. Passed it on to the carrier. They said, well, it's not really a claim, but it is a written demand by a government agency for documents. So it's just like a subpoena, and we cover subpoena defense. And that's how I got the case. I had some constitutional cases earlier in my career, mostly police brutality issues, but this was a long time ago. So the first thing I did was figure out, along with an associate I was working with at the time, this can't just be Thomas More Law Center got this demand. It's got to be everybody, right? So I asked the associate to look around for other cases against the California Attorney General, who at the time was Kamala Harris, who I voted for twice, just so you know, and looked to see if there were other cases about this, and they started popping up. One was filed already in the Central District Federal Court by Americans for Prosperity Foundation. So I made contact with that group and their counsel and got some initial pointers. And the next thing I did was to call up the Attorney General, not her personally, but the person who runs their registry of charitable donations. And I said, I'm going to have to sue you, and I don't want to. We could resolve this right now if we just agree that while this Americans for Prosperity case is going, you won't enforce your order against Thomas More Law Center. Everything's on hold as to Thomas More. They said, no, we can't do that. So I had to file the lawsuit somewhat reluctantly against Ms. Harris in her official capacity, but very wholeheartedly for Thomas More Law Center's right and that rights of their donors for privacy and to associate in their activities as an advocate. So that's what got the case to court. There had been a case. You may say, how do you get a case to court and how do you go in the Supreme Court? It really helps if about 60 years before your case, the Supreme Court unanimously decided another case that is pretty much right on point. And that was NAACP versus Alabama. So the very first sentence of the complaint for Thomas More started with, in NAACP versus Alabama citation. And you might say, well, that's a weird way to start a complaint. And it was, but it brought forward, this is our main point. This is this is the case that we want the court to focus on more than any other. So after that, and I'm not going to go through all the trial, of course, because this is really about the Attorney General and the Supreme Court phase. The first thing we had to do was figure out, how do we get proxies for the donors? We can't go to the donors who are anonymous and say, hey, would you do a declaration under penalty of perjury that we can provide to the California Attorney General who wants to know the names of the donors? That would be a little bit self-defeating. So what we came up with was to use as proxies people who had been represented by the Thomas Law Center in court, because obviously their names are public record, and that's the evidence we based it on. We and the Attorney General's office agreed early on to waive a jury, have a bench trial. That becomes important at the Supreme Court end of the story. And our trial judge was the late Judge Manuel Real, although it's R-E-A-L, he pronounces it Real, and been on the longest serving federal court judge appointed by President Johnson, Lyndon Johnson, in case you were wondering. And he heard both the Thomas More case and the Americans for Prosperity case separately. AFPF went about 6 months before we did, because they filed first. There were two big issues in the case that we, in doing an as applied challenge to the Attorney General's demand, had to face. One is to show that we've been harmed, and the proxies helped us to do that. The other was to show that the Attorney General doesn't keep the information private, that it, as we put it, the system leaks like a sieve. And that phrase came up again and again throughout the course of the case. So we had an expert who was a data person who showed how easy it was to hack the Attorney General's registry. And we had the author of the only peer-reviewed study of anonymous donor behavior, guy from Boston College, who was a recently retired professor, that said that this is exactly the kind of chilling effect that the Supreme Court in the past has said we shouldn't have. We don't want to dissuade people from donating charities because they have concerns about their privacy being breached. When it came time for experts, we designated ours. The Attorney General did not designate an affirmative expert. They did designate a, quote, rebuttal expert who was a different Boston College professor, but a law professor. And our professor was a sociologist, and I thought it a little odd. So I called them up and I said, you can't really rebut a sociologist with a lawyer, can you? Oh, sure we can, not to worry. I said, okay, I'm going to tell you, I'm going to have to bring a motion to recuse. Well, go ahead. So at a trial, I did bring up that motion. And after some voir dire of the witness, which included, have you ever taken a course in sociology? No. You ever write anything about sociology? No. He said, move to strike. And Judge Real said, the witness is relieved. So that was an interesting thing to do at the trial. We had two trips to the Ninth Circuit in this case. The first was at the preliminary injunction phase. Judge Real had granted our motion for preliminary injunction. The Ninth Circuit reversed that, but did leave in effect the portion of it that said the Attorney General's office must not distribute the information. They can still collect it, but they can't distribute it. We went through the rest of the case, including the trial. We got the permanent injunction and the judgment on that injunction. And at that point, the AG went up for a real appeal of the judgment. So two trips for the price of one. We lost in the Ninth Circuit. Vote was 3-0 on that panel. And we requested en banc rehearing, which was denied, but a number of the Ninth Circuit judges did side with us that the issue should have been reheard because of reasons like it violates NAACP versus Alabama. So it became time to go to the Supreme Court. I'd never been to the Supreme Court except in my first year associate role of doing a document review in another building nearby, and just happened to take some time to walk through. So that was my only trip ever inside the Supreme Court. I told the client earlier, if this case goes any higher, and I was talking the appellate phase, you might want to bring in a ringer. I've been to the Ninth Circuit a bunch of times, but this is a big case. And Lord knows, if either side appeals, you're probably going to do better with somebody who's been a winner a couple of times. We found somebody who did it, John Bursch, B-U-R-S-C-H, not Birch, B-U-R-S-C-H, who's with the Alliance Defending Freedom, who agreed to do it for free. And John's record up until this case was 11 wins, 0 losses. My record up to this case was 0 wins, 0 losses, 0 tries. So his record has now improved to 12-0 and mine is 1-0. He was the main attorney for Thomas More through the Supreme Court phase. He was essential in the petition for certiorari, and essentially had the strategy that we needed. I had made all sorts of things in the trial court, breach of every clause in the Constitution I could think of, plus a few other things. And John had the sense to narrow it down to one issue, the freedom to peaceably assemble. I thought it was mostly a free speech case. He got it right that this isn't an individual speaking freely. This is a group of people advocating together. So the right of assembly turned out to be the key one in the case and the thing that the Supreme Court mostly relied on. He also taught me a new phrase, a clean vehicle. I thought, was that a brand new Tesla or what? No, a clean vehicle is a case that comes to the Supreme Court with a good record. That is to say, an almost perfect evidentiary record and a clear issue. And something else, a split among the circuits on the same question. So the Ninth Circuit obviously ruled against my side, and 2 other states, actually 2 other circuits and 1 other state had the same idea that donors should have to disclose and not become anonymous. The rest of the states and the rest of the circuits had not done that. So there was a split among the circuits, and this was a clean vehicle for the Supreme Court, not just to decide for Thomas More or AFPF, but also to decide, is the standard such that it should be applied across the country to all nonprofits? And it was a clean vehicle to do that. So at that point, we wanted to say that the Supreme Court has an opportunity to protect the NAACP versus Alabama precedent. And that got us to the day of January, well, there were a lot of briefs in the middle, but January 8, 2021 was the day that we got news that the Supreme Court had granted certiorari. I had figured, there's a 3-hour time difference. It's after 2 o'clock. So they're all heading home. It was a Friday as well. Everybody's heading home. I'll go get a haircut. So I went and got a haircut. And while I'm sitting in the barber's chair, I get a call on my cell phone. It's John Bursch calling saying they granted certiorari. And I had to explain to the barber what that was about. I said, John, I'll have to call you back. There's a guy cutting my hair right now and he's got sharp objects. So shortly after that, I finished the call with him and we started making plans for the real thing. We were greatly assisted in this case by amicus curiae briefs. there were something like 40 amicus briefs between us and the AFPF case, representing over 250 amici. 40 briefs had some briefs had multiple amici in them. That's why the disparity of numbers. They were incredibly diverse. We had the NAACP, we had the American Civil Liberties Union, we had the Institute for Free Speech, the Hispanic Leadership Fund, National Association of Home Builders, go think about that one, and a whole bunch of others. And the court even commented in the majority opinion about the diversity, all sorts of different sides of the political spectrum that had lined up on this issue. Just have to check my time. I'm okay. You may ask, how do you get so many amici? Well, there are organizations of nonprofits, and a couple of those organizations allowed us to speak to their members by phone call, conference calls, long before we got the merits brief written, to tell them what our case was about. And then they talked among themselves and said, all right, we want to support on this issue or that issue. And it wound up with 40-something briefs. And that's how that happened. Without that kind of an associational background, we would never have gotten the quality or the number of amicus briefs that we actually had. Then we had, of course, we already had filed the record, and the time came, the big scramble to write the briefs. One of the nice things about my relationship with John Birch and Alliance Defending Freedom was they didn't simply take over the case. I wrote about half of every brief that we filed. And of course, they greatly amended it to make it make more sense. But I was certainly in the mix throughout the thing. For the preparation for the hearing, John was going to be our lead counsel, of course. He would be doing the argument. However, the Supreme Court decided that Americans for Prosperity and Thomas More would be heard together, and that they had to have only one spokesperson for both organizations. So how do you decide that? You know, pistols at 20 paces? Almost. The way it's traditionally done and the way we did it is a moot off. So John and the Americans for Prosperity lead counsel had 4 or 5 moot offs where different people played the Supreme Court justices and decided finally, they made the decision among themselves that AFPF's counsel would be the lead. So I was disappointed with that, but Derek Schaefer, who was their main counsel, did a really excellent job with the Supreme Court oral argument, I thought. And it must have because we won. Now the hearing, as I said, my only real appearance in the Supreme Court was as a first-year associate. I didn't even get inside the building this time. It was completely shut down. The entire argument was done, not even on Zoom like we are now. It was done on a telephone conference call. So AFPF's counsel and ADF's counsel and I were all together in a conference room in a law office not too far from the White House. And we were on a joint conference call with the 9 justices and also the Attorney General's counsel. Strangest thing I've ever experienced. I did wear this suit. This is my law suit. First thing after I told my wife that we had certiorari, she says, we got to buy you a new suit. So we went to Nordstrom's and she got me this Hugo Boss 3-piece suit. I only wore 2 of them today. This is the same suit, tie, and shirt, though the shirt's been washed a couple times. And I don't know why I got up on that tangent, but everybody was all dressed up to the nines in that conference room. And we had no mental image of what the justices were dressed in. They weren't even in the same place at the same time. So Chief Justice Roberts, of course, get to go first. And then he passed it down in the order of seniority. So Justice Thomas was next, and all the way down to Justice Barrett, the newest one. And he did the timing on it. And it wasn't a strict timing. You can hear the full audio transcript, if you want to, of the oral argument from the Supreme Court's website. I thought it went very well, and for us, and I guess maybe it did. So the decision comes out July 1. I won't say I fainted because I had high hopes, but the fact that the Chief Justice was the main author of the majority opinion meant a lot to me. The fact that he is not as doctrinaire as some of the others on the court are, so certainly more of a centrist. And I think he did an excellent job with the decision itself. So what happens now? Right now, I'm still in the case. In fact, I'm lead counsel again because we're back in the district court, Central District of California, bringing motions to have fee awards for both Thomas More and AFPF, and for ADF too. And that's where we are. And since those are pending, I really can't talk about them, but it's not over yet, folks. And as you probably know, presiding party in a 42 USC section 1983 case, Civil Rights Act case, is allowed to be awarded attorney's fees and costs under section 1988. So that's what we're doing. And at this point, I think I should stop talking and give my friend Chloe a chance to ask any questions she may have before she reads some of your questions. Is that okay with you, Chloe?
That sounds like a plan. Sounds perfect. So I've prepared some questions, and I had in mind that a lot of the attendees today were students. So I tried to pick some questions that could serve as practical advice for our students, especially those who are interested in litigation. So I'm going to ask those questions, and then if anyone had questions of their own that they thought of during Louie's presentation, go ahead and pop them in the chat. And then when I'm done with my questions, I'll read those out and give Louie a chance to answer them. So first, I wanted to ask that, most of your experience has been on the defense side of the aisle, and this was a little different because now you are representing the plaintiffs. So what are some key differences you noticed kind of working on the other side? And in the future, would you be interested in representing more plaintiff side, or would you prefer defense work?
Wow. The biggest difference is that the plaintiff's counsel sets the table for the whole case. He or she is the person who writes the complaint and has to do what I had to do in this case. What are the causes of action? What are the things we allege were violations of the Constitution? And as I mentioned, I went overboard. I threw in the kitchen sink, probably because of my inexperience. It was all there. It was all in there, and it turned out only one of them really had to be there. But at least I didn't leave it out. So that's the big difference. And on the defense side, you don't make up new theories that the plaintiff can use. Obviously, you have to respond to the ones that they come up with, and come up with affirmative defenses or demurrers or motions to dismiss, etc. But the plaintiff's counsel really does set the table. And that was perhaps the biggest difference. The other was, this case had a special meaning for me because except for some of those police brutality cases way earlier, I hadn't really dealt with constitutional cases before. And I, like probably everybody on this Zoom, I've always been a big fan of the First Amendment. People interpret it different ways, but it's the thing that most sets us apart from other countries at the time that the First Amendment was enacted and made part of the Constitution. That's the main thing that sets us apart, even more so than the three tripartite federal government. So most lawyers, I think, and I hope most citizens understand that the First Amendment is their greatest bulwark against abuse by governmental agencies. And that meant something to me. And I was able to represent a client who I do not agree with everything they advocate for, but I could agree 100% with their right to advocate for those things. And that's what was at stake here, not the outcome for a particular point of view, but a victory, as it turns out, for everyone's right to advocate communally with others. Was that a long-winded sentence? Probably.
I think that was great. So I want to ask, so that you were on this case for the long haul. So this case was first filed in 2015, and now we're in 2021. So I want to ask, how were you able to keep your momentum going, throughout that long, I guess, 6-year period?
Yeah, running on 7 now.
Yeah,
well,
still going. Great.
Going. I should mention, by the way, this is not my actual library back here. I have not lived in a library for the last 6 years. It only feels like I have, because this certainly was the most law-intensive case I've had. And that really did keep me going. I will say this without trying to be cute about it. I was exhausted by the end of this case. And there were parts of it in the middle of it where I was downtrodden. Certainly the 2 rulings by the Ninth Circuit didn't do a lot for my feeling of optimism, though I did really think if the Supreme Court took it, we had a good chance. And 2001, after January 8th, was a marathon. And come about, the hearing was April 26th, as I recall. Around about February, I was really tired. And my doctor said, you have to take a leave. And I said, I can't take a leave. April 26th is a hearing. And my doctor said, okay, well, May 1st, you're on 6 weeks, 6 week off work on medical orders. And I did that. And it was wise advice. But I was, I'm 67 years old. I don't look more than 95, but I was tired. And the thing that kept me going was that there really was a cause here. It's not just like, oh, I have to answer interrogatories today. I have to write some requests for admissions. No, this was a big deal on an issue. The issues described in this book, which some lucky raffle recipient will get autographed. And it was something meaningful to do. If I died the next day after July 1, I'd die happy knowing I did something that meant something.
So my next question is kind of on the same topic, but maybe slightly different. We talked a few months ago now, you and we had an interview over Zoom, and I asked you kind of how did you handle the stress of all this? And you made me laugh because you said something like, oh, I didn't handle it very well at all. But I want to know if now, looking back in hindsight, if you have any advice or tips that you would have followed that you think would have helped you balance your kind of work, household, life balance a bit better.
Looking back on it, I'm sure there are a lot of things I could have done better. Um, I owe a great deal of gratitude to my wife, who had to listen to me every day talk about the Thomas More Law Center, and it became the subject of every dinner conversation. And instead of boring her to tears, she nodded her head and asked questions like she was fully interested in it. And she is a registered nurse, so she did a great job of telling me, Louie, you look like hell. Why don't you do something else today? And that helped a lot. I also had great help from our dog. We have a 3-year-old German Shepherd mix named Opal, who insists on very long walks multiple times a week. And I think she did a great job of keeping my vim and vigor going. Oh, I also, I'm going to anticipate this maybe, but I told the firm after January 8th, I can't keep up my regular caseload and do this. I'm the only one who can do this, not because I'm special, but because I'm the only one who's worked on this case since the very day it came in. And so I have to be involved in this case. And that means that some other clients are going to have to work with other people here in the office. And I felt bad about that. I felt guilty because I was, leaving people high and dry, except the firm came through and found others probably more capable than me to handle those cases that I had to give up. And I think that is a lesson that you don't have to go to the Supreme Court to learn. If you are under a lot of stress, whether it's work stress or whatever else, you have to take care of your health, and you're not doing your client a good service if you work while you're exhausted. They're not going to get your best work if you're exhausted or stressed out, and there is help available for that, not just from a wife or a dog, but there are professionals who help with that sort of thing. And it's important to see it coming. It's like the train at the other end of the tunnel. You know it's coming, and there's time to get out of the way of it. Bad analogy, I guess.
I know at this point now you've said that you believe you made a lot of mistakes and that there's a lot of things looking back that you would change. But I want to know not necessarily about the actual legal issues, but if you were to go back, is there anything that you would change about your preparation and your approach you took to this case?
I guess the biggest one is, although I joked with the associate who I mentioned, this case could go to the Supreme Court someday. And then we both had a good laugh. I didn't treat it that way early enough. I didn't document the case as well as I could have if I'd really thought the Supreme Court's going to take this someday. And even some of the pieces in the trial record and the evidence at trial, we got everything in that we needed, but it wasn't pretty. And a case like this, you'd like it to be pretty as well as accurate. I think that's probably my biggest oof. And if I could go back in time, I would have made sure that we had all that I's dotted and T's crossed.
Something that you shared with me that I found really interesting, kind of on the more like personal approach to this case, was the fact that early on you had spoken to your clients and mentioned that if this were to go all the way up to the Supreme Court, maybe they should pull in a ringer, as you called it, someone that had experience, arguing in front of the Supreme Court. And I think that showed a lot of humility, but would have also been a really difficult decision to make, because we were talking, we were saying, every person that's in the legal field in some way probably imagines that someday they'll be arguing a case, in a fantasy, imaginary scenario. Oh, I'll be arguing in front of the Supreme Court one day. And you imagine what that would be like. And then to turn that down, especially so early, and kind of take that opportunity away from yourself, I think would have been difficult. But I mean, you showed a lot of humility in that decision. So can you just talk a little more about that?
Well, I have many good reasons to be humble, but that helps. This was really a question of just getting the issue out there on the table, that I've never been to the Supreme Court before. And I guess I've not argued before the Supreme Court, though I was in that conference room and writing notes to the other counsel feverishly. But they never heard my voice. They never saw my face. And I don't, in a way, I would not have gotten the chance to argue before the Supreme Court, even if I'd given the argument. But why would you have a first-year law student do brain surgery on you? You would. Did I say law student or medical student? I said law. I meant medical student. You wouldn't do that. And I did say, if you want me to take this all the way, I'll do it. I will look to others for help and guidance. But if you want me to do this all the way to oral argument, I'll do it. But if I was the client, that's not the decision I'd make. Get a specialist. And the response from Thomas More Law Center was, we want you on this, certainly all the way through the Ninth Circuit. And then if it comes to that, we'll talk about it. And Richard Thompson, who's the president and chief counsel, said, but let me tell you this, if we ever do that, you're still on this case because you've gotten us this far. And he was there every day of the trial and thought it went really well for us. And he said, and you've got the institutional knowledge of this case. So we can't do this without you. And that felt great. And it certainly took away any sting of, I didn't get my chance. No, it worked out just perfectly, except for the COVID thing.
Perfect. Well, that's the end of my prepared questions, and I haven't received anything in the chat so far, but if anyone has questions, go ahead and pop them in the chat. I also, Professor Brockle and I were able to figure out the raffle winners during the presentation, just so we could get that out of the way. So I have those ready to be listed off, but before I do that, and pending any questions in the chat, Louie, did you have anything else that you wanted to say at the close of your presentation?
Yeah, and I'm glad I had the chance to. Timing doesn't always work out as well as you hope. So I want to tell you how much I'm enjoying what I'm doing at GGU. I, for years, had wanted to teach something. My grandmother was a teacher. My mother was a teacher. My sister was a teacher. I guess it's in the blood. And it took me a long time to kind of pull the trigger and say, okay, I'm going to apply for a teaching job, while keeping my day job, which I still do. And I met a GGU professor who's not a law professor, but teaches Chinese law and international arbitration. We met at a bar of San Francisco, Bar Association of San Francisco mixer, and started talking. And I mentioned that I'd always wanted to teach. He said, well, why don't you come with me over and I'll introduce you to the people there, and we'll see if there's any interest. I was shocked. Like, that's not how things get decided in universities. Turns out they are. So next thing you know, I got a chance to fulfill that lifelong dream. And I'm still learning. As any of my students can tell you, I have a long way to go in learning how to be a law professor. But this has been a great opportunity. And I'm, as a person who, back at Bolt Hall, as it used to be called, wore the lapel button, because he also had lapels back then, hire more women and minority faculty at Bolt. I still have that back here somewhere. I'm just so happy to see the diversity of our student body. And just, it gives me great hope for the future that things don't have to be the way they used to be. And you're the ones who are going to make that change, not me. But it gives me great pleasure. Thank you.
Right, so I received a question in the chat, and then a student also private messaged me a question they'd like me to ask. So I'll start with the question in the chat. Are there any thoughts or concerns about the impact that this case may have on campaign finance laws?
There's been a lot of press about that. I personally don't have any qualms about it because 501c3 corporation, which is what we're talking about, IRS code 501c3, my nonprofit is one of those as well. You cannot give money to political candidates or to ballot propositions. You can't use money that you take in as a charity to fund political campaigns. Now, does it happen? I'm sure it must happen. But this court case will neither stop it or advance it. I think this case is neutral on that. And so I think there is a real issue in the country about campaign financing. I wish we had a better solution for it than our current method. But I don't think Thomas More Law Center or any of these nonprofits should risk their license by giving a nickel to a political candidate.
All right, I've received questions from two different students now in my private messages. So I'll start with the first question. A student would like to know, does Professor Castoria feel that the Attorney General's office is upset with him, and has he had any other cases dealing with the AG's office since all this happened?
No, I still have the one that I still have, but I haven't had any others since this started. And I doubt very much that they have any personal animus toward me. Not that I'm such a great guy or anything, but we kept very good interpersonal communications throughout this thing. And there was one of their lead counsel, who's no longer with the office of the Attorney General, and I were at my client's depositions in Ann Arbor, Michigan, and he was on different flights than I was to return, and was afraid of missing his flight. I said, well, I've got a rental car, so you don't lose time waiting for a taxi out here in the middle of the boondocks. Why don't I just give you a ride to the airport? I'm going to the same airport, but my flight's 3 hours later. So we did, and we talked, had a nice long chat in the car about everything but the case. And that's how it used to be among lawyers, and I think that's still how it ought to be. We talked about his children, my grandchildren, and it's a good relationship. And like I said, I voted for her twice, and her name's not even on this case anymore. It's Rob Bonta now, and she's gone on to bigger and better things.
Okay, so the last question I have received in my chat is kind of a multi-part question, but I'll read it out. So let's see where it starts. Here we go. Is there anything you did or do to prepare arguing in front of the Supreme Court that is different from arguing a regular motion in front of a less prestigious court? Or did you prepare virtually the same way? And do you ever go so far, or did you ever go so far as to tailoring your arguments to the justices sitting on the bench?
A really good question. And it was a lot the same, except I never had a case where we did, 5 moot courts before oral argument before. I've done moot courts before oral argument and gotten a lot of benefit out of those. And that's one of the things that we do at my firm in our appellate practice group is to provide a panel of moots to help people hone their arguments. But there was so much briefing in this case. There was the petition for the writ of certiorari, and then there was the opposition to that, and then there was our reply, and there was a SIR reply, and there were a lot of back and forths. There was also a change in the administration during the course of this case. And so the Attorney General's office had a different take from the US Attorney General's office on the case than the original one did. Anyway, what I was getting to is, with all this briefing, before we've even got certiorari, you're already narrowing your arguments. You know who the 9 justices are likely to be, although there was a change or two in the middle. But you know pretty much who your audience is, and you want to look back to their cases and the cases that they cited in their cases much more deeply than I had ever done before, which is why I talk about being in a library for 6 years. That was different. And of course, the setting for the oral argument was different and one I hope never to be repeated. I hope that answered that question. I'm not sure if I did.
I think you answered it. So that was the end of the questions that I received in the chat. So I think we'll move forward with announcing the raffle winners. So there was 3 raffle prizes, and we kind of just do a random number, and then Professor Brockle counts up to whoever's that number on her screen, and that's how we determine the winners. So the first prize is playing cards, a set of playing cards with a picture of the Supreme Court on the back of the cards. And that is going to Dave Bertini. So congratulations. And if you win any of these prizes, just email baxterfellow@ggU.edu with your mailing address so that we can get these sent out to you. So congratulations, Dave. The next prize is a book, which is The History of the Supreme Court, and that is going to Miss Christina Robinson. So congratulations, Christina. And then the final prize today is a signed brief, and that's with, I think Professor Castoria flashed that on the screen at one point, and that is going to Gabe Flesher. So congratulations, Gabe.
Hi, Gabe. Congratulations. Gabe was in my class last spring.
Oh, very cool. All right.
Yeah.
Well, congratulations
so
to
much.
our raffle winners. And thank you so much to Professor Castoria for being here to share his journey with us. And thank you to everyone for attending.
Thank you, everybody.